Hi everyone, my name is Catherine Honeycutt, Communication Specialist for BBB, and I'm excited to welcome you to our BBB Business Builders webinar featuring Rick Cannon from Cannon Law PLLC to discuss employment law in regards to COVID-19. Without further delay, we'll dive into today's webinar, but if you have any questions throughout the presentation, please feel free to put them in the questions box and we'll be sure to get to them during the presentation. So with that, Rick, I'll pass it over to you and let you get us started.
Thank you very much, Catherine. Good afternoon, everybody. I'm Richard Cannon here from Greenville. I just want to tell you a little bit about myself. I'm very delighted to be here this afternoon and talk with you a little bit about this employment law issues that are coming up right now. I know they're hitting everybody, including law offices. So if you'll bear with me, I've been practicing law since 1983 here in Greenville, and my law firm is Cannon Law Offices, PLLC. Most of my practice deals with Social Security, disability, bankruptcy, and workers' compensation. But by necessity, as a lawyer and running a law firm, I've had to deal with many employment issues, even with one of my own employees here recently with regard to employment security issues. I'm a graduate of Campbell University School of Law and the University of North Carolina, and I'm a member of several of the bar associations. So I'm really excited to be here. What I'm going to talk to you today about is unemployment benefits. Primarily, my focus will be on that, both before this pandemic hit us, and then what the government's response has been and how that post-pandemic response has affected us. So I'm going to talk a little bit about the background, then how it's funded, and then a little bit more about how you apply. And then we're going to skip over here and talk about unemployment benefits post COVID-19, what the changes have been, the new emergency programs that have been implemented, and the application process for that. Just by way of background, the Social Security the Social Security Act of 1935 was what created this unemployment situation. As you probably know from your history, the Great Depression occurred during that time, and Franklin Roosevelt was in office, and it was very obvious to everyone at that point that people needed help, and unemployment was at a record high at that point. I think by some estimates, more than 25% of the working population was unemployed at that time. And so coming out of the Great Depression, there were several acts that were passed, including the Social Security Act of 1935, which has basically been adopted or been utilized by almost every state. I believe every state in the union now has some form of unemployment compensation. In our state, it used to be called the Employment Security Commission. Now it's the Division of Employment Security, which is part of the Department of Commerce. You'll find the statutory background, and the statute that deals with employment security law is found in Chapter 96 of the North Carolina General Statutes. You'll also find in there that the purpose the legislature had indicated was to set aside, and this word is key, compulsory, compulsory setting aside of unemployment reserves to be used for the benefit of persons unemployed through no fault of their own. So the idea behind unemployment in the beginning was it was going to be a temporary measure. And North Carolina has made it very temporary. They only allow on a regular basis 12 weeks of benefits. I saw somewhere where I believe we're ranked 49th in the country in terms of our employment benefit program. You'll also find regulations regarding employment security in the North Carolina Administrative Code, Title 4, Chapter 24. You'll find also in there copies of the executive orders that have been issued by Governor Cooper, which makes several changes, which we'll talk about as we go along. One of the key concepts about employment security laws is it's intended just to be temporary, to give people enough money to get by until they can get another job. So employment security the Division of Employment Security does more than just pay out money. It administers several funds that come in from various sources, such as you as an employer. Of course, you're going to be paying for that, but they also have other funds that come in as well. They also are going to help people find jobs. And then finally, which sometimes we don't like so much, they are responsible for the enforcement of the employment security laws. So that's pretty much how the background of that. Let me go on to the next slide and talk about how it's funded. The employment security is funded by a state unemployment tax, and all employers are required to pay that tax each calendar year. And it basically is an amount equal to the percentage of taxable wages that the employer pays its employees during the calendar year for services performed within North Carolina. Now, of course, as the slide indicates, you can't deduct that from the employee's wages. And the percentages on that, if you're a brand new employee, less than a year, then you'll start out probably at a percentage range of 0.01%. It can go up for an experience rated employer to up to 5.76%. What I mean by experience rated employer would be an employer who's been in business, employing persons more than 12 months, and they're rated according to their performance. If you have a lot of employees that end up that the fund has to pay because of them being separated from their employment for various reasons, then your employment rating would go up. Your percentage would go up to some degree. But as long as you don't have anything charged to your account, then the way it generally works is you're going to have a more minimal employment rating. So that works out really good. Now we're going to find as along there's several changes that have taken place that change the way things are charged. As far as applying for employment benefits, historically, before this pandemic occurred, a person could apply for benefits, an employee could apply for benefits if they were out of work through no fault of their own. Well, in the current epidemic, we're taking the position, or government's taking the position that this pandemic, of course, is not the fault of the individual. It's the government has basically seen fit, and rightly so, to basically shut down the economy, and that has effects. That has economic effects on everybody. So it's basically not the fault of the employee that they're out of work right now. If their hours are reduced, or they're laid off, or there's a reduction in force, then they can also apply for benefits. Interestingly enough, if the employee quits their employment, as a general rule, they may not be eligible for employment benefits, but if they have a good reason for quitting, then they may still be eligible benefits. Now, in that situation, there may be circumstances where the employer would not be charged, but the employee would still receive benefits anyway. Now, if an individual is fired, they're presumed to be eligible for benefits unless the employer can show good cause or misconduct on behalf of the employee, or substantial fault in the performance of the employee, or some other reason not attributable to the employer. So the rule has always been that the individual has to be able to work and actively looking for work. There are requirements in the statute for weekly efforts to try to get a job. This has been temporarily suspended as a result of the COVID-19 legislation. In fact, the governor's order has done that. Benefits are calculated based upon the wages in the last 2 quarters based on a base period of 5 calendar quarters divided by 52. And the maximum benefit is $350 per week, and that would be paid for a maximum of 12 weeks. Now, as you may be aware, and we're going to find out later, this time period has been extended by the federal action to an additional 13 weeks. With the things that are happening these days, it seems pretty clear that we're not going to get back to work anytime soon. And so it remains to be seen whether this time will be extended beyond 13 weeks. If you recall, back in 2008, we suffered a fairly severe recession, as you know, and following that recession, just like after the Great Depression, there was a lot of legislation regarding employment benefits, and the EUC of 2008 was passed. And in that case, benefits were extended up to 73 weeks. So there's every reason to expect that depending on how long this pandemic lasts, we could see some changes in that in the number of weeks that are allowed. I think right now it's only at 13 weeks, and we'll get to that a little bit later. Now, let's talk a little bit about the post-COVID-19 changes. That's really what we're all about. What do we do now? How do we navigate this bumpy water that seems to change from time to time, and things seem to change? Well, the first thing that I refer to is Executive Order 118 and 131. Governor Cooper issued that order, and it made a number of changes in the way unemployment benefits are paid and in the way they can be applied for. For example, .0101 allows the person to apply immediately upon reduction in hours or upon leaving their employment. They can apply immediately. There's no 1 week waiting period. The work search requirement has been suspended, and that was from 96-15.01. There are several notices that have to be given to the employee that you may be aware of, and there are even some posters that you can order, I believe, from the Department of Employment Security. But the main thing you've got to notify the employee is the notice of availability of employment compensation at the time of separation. Excuse me. So if someone leaves your employment or their hours are reduced, at that point, you've got to notify them that they do have benefits available to them if they meet the state's eligibility requirements. They may file a claim in the first week their employment starts, so their hours are reduced. They may file claims online at des.nc.gov or by telephone at 888-737-0259. And they also have to provide their full name, their social security number, and an authorization to work if they're not a U.S. citizen or resident. So those, the direction basically is to contact DES, and everything goes through their DES website. Now, at this point, I want to make note of one particular point. Make certain that when they fill out their paperwork, make certain that they put that the reason for separation is due to coronavirus or COVID-19. If it's for any other reason, then none of these new rules or new provisions apply. We go back to the old statute, and they have to conform to that. All right, there are at least 3 new emergency programs that have been passed in recent weeks that apply to unemployment in North Carolina. One is the Federal Pandemic Unemployment Compensation Act. Second, the Pandemic Emergency Unemployment Compensation, or PEUC. And then finally, the Pandemic Unemployment Assistance. Now, they're all different, and let me go through each one of those, explain to you how they work and how it applies in your particular case. And again, I'll point out to you there are a number of tips and papers that can be gotten from the DES to help you with that. First of all, the Federal Pandemic Unemployment Compensation Act is the big one, because that provides for increased unemployment benefits for anyone who is out of work due to COVID-19. It's effective from March 29th, 2020 until July 31, 2020. Again, Depending on the circumstances, that could be extended, but right now that's what it is. The benefits are payable to anyone who's been quarantined, or they're taking care of someone who's been quarantined, or taking care of a family member who's sick. It also goes to family members who are homeschooling their children because they can't go to school, if their hours have been reduced, if they're working at home, if their business is temporarily closed. Those people are all eligible for that extra $600 a week in addition to the benefits. So they can get up to $350 on the state unemployment, and then an additional $600 a week in addition to that. So that's the federal pandemic. Now, the question that's been raised, and again, employers are not going to be charged for this, as long as you put on there, okay, as long as it's put on there that it is due to the COVID-19. That's very important. Now, the question comes up, and the question may come up in your mind, well, what happens when these conditions are removed? And that's a really good question, because I don't think anybody knows exactly what's going to happen on that. Under the previous statute, and before this was all changed, if the circumstances changed, in other words, if you got to a situation where you said, hey, I no longer have work shortage now, I need you to come back right now, I need you to come back in, I've got hours for you, I've got a job for you, and so forth. Under the previous statute, that might serve to disqualify the individual for further unemployment benefits, whether they went back to work or not. If the work was available and they didn't go back, then they might lose their benefits. If they continued to receive benefits, they might be subject to an overpayment, which would be a real problem there. So I don't think anybody really knows exactly how this is going to play out once we get fully phased back in to the reopening of the economy. But my guess is that if they still have children at home, then there's going to be an issue with that. Or if they have someone who's dealing with coronavirus, that's going to be an area where we're probably going to have some litigation, probably going to have some discussion about that in the legislature, and so that may be an issue. So I just want to point that out to you, that that could be an issue. All right, going to the next new law would be the PEUC, which is the Pandemic Emergency Unemployment Compensation Act, and this is the one that extends the unemployment benefits for 13 additional weeks after the weekly North Carolina benefits are exhausted. Now, this is a really good thing because, as I said, North Carolina only allows 12 weeks. So this is additional 13 weeks can be added onto that for a total of 25 weeks. Question there is that going to be extended? We don't know at this point. The nice thing about the CARES Act and this unemployment is it is retroactive back to March 29th. So if you haven't applied and you were out of work then, you can still go back and apply for retroactive benefits. I did want to point out, I just noticed in the news the other day that as of April 15th, more than $100 million has been paid to unemployed persons in North Carolina so far. Now, the next emergency act, which would be the next slide, would be the Pandemic Unemployment Assistance. This is an unprecedented expansion of unemployment benefits. As you will note from the statute, part-time, self-employed, independent contractors, and freelance workers were originally not eligible for regular unemployment compensation. However, with the passage of the Pandemic Unemployment Assistance Act, unemployment benefits now are available to part-time workers, self-employed workers, independent contractors, freelancers, and also individuals who have exhausted any extensions to unemployment insurance. So if they've gotten to the end of their time, they can apply under the Pandemic Unemployment Assistance Act and possibly get more benefits. This the filing date for beginning of this was April 24th, so I take it several people have already applied for that, I'm sure. The other nice thing about the Pandemic Unemployment Assistance program is that the $600 a week that was granted through the federal benefit is also included. So not only can they get regular benefits, but they can also get the $600 a week additional benefit. Now, question there is, when they run out of their time on their regular unemployment, can they extend that? Well, the issue there would be probably not, unless the legislature sees fit to go and extend that time. But at least they would get the $600 a week beyond the original 25 weeks of unemployment. So that's a huge change in the way unemployment is dealt with. Up to this time, in fact, I believe even, I may be wrong, but I believe even after the recession of 2008, I don't believe unemployment was extended to non-full-time employees. So that's a huge change in the law. And so if you are a sole proprietor, even if you're a business person who or owner, and you typically pay yourself wages, then you may be eligible for some of these benefits as well. Definitely encourage you to look into that. The application process, going to the next page, the application process, again, is as simple as dialing up des.nc.gov. You want to go in there and choose coronavirus as the reason of separation if your hours are reduced, and complete the weekly certification each week if you're an employee. And of course, your eligibility will be determined after the claim is filed. I do want to mention something about this. What's going to happen is you're going to receive a notice when your employee files for unemployment benefits. You'll get a notice, and that notice will include with it a request for separation information. I just got one, and you're given, I think you're given maybe 10 days or 14 days. You're given a few days to respond. So I immediately jumped on the computer and started trying to dial into DES and let them know that, hey, yeah, this is coronavirus, and I want to report that. I want to confirm that. And I tried, never could get to square one on that thing. The website was overwhelmed, and you may still find that to be the case. Hopefully, it has not as busy now as it used to be, as it was in the initial. But I was very pleased to note when I got the determination. I stressed about that until I got the actual termination, granting the unemployment benefits and confirming that I didn't have to take any additional action. That it was not going to be charged. I was not going to be charged, and everything was fine. So you may be okay anyway, but I would encourage you to try to go onto the DES portal and make sure that you indicate that separation was due to the coronavirus and that you don't want to be charged. So let me talk a little bit now, if I can, shift gears to a little bit about the employer perspective on this and how this can affect. It is possible, and the statute allows for an employer to file what's called an attached claim. An attached claim, as the slide indicates, is a claim that's filed by an employer on behalf of an employee who has been temporarily laid off or is working less than 60% of their customary scheduled full-time hours. Now, historically, that was an issue, okay? Because if you filed an application for your employee, you had to prepay the cost of that unemployment at the time you filed the application, especially if you didn't have a credit balance with DES. You could only file for up to 6 weeks of benefits, and you couldn't do it but once a year. Well, all that's been changed by Governor Cooper's Executive Order 131. You don't have any prepayment anymore of employment benefits. It's not required. You also don't have to. You can file for more than 6 weeks, and how many more than 6 weeks you can file doesn't say. And it doesn't say in the executive order, but I would apply for as much as you could. You may be able to submit an attached claim more than once a year. So if you submit one, you may still be able to submit another one. And there's no positive credit balance is not required. Now, this is effective as of April 1, 2020. Again, doesn't appear to be any termination date on that, but again, I think there'll probably be additional legislation or regulations that will probably address that. Now, going to the next, the problem you've got with attached claim is you're doing something for the employee, and that's good, but that could expose you to some liability. Okay, if you fail to do the right thing and they end up not getting their benefits, or you do the wrong thing and you end up getting charged, then that could be a problem. There may not be any way to get around that. Another thing to be aware of is if you've let somebody go and you say, well, I'm just going to give them a severance package. Well, the problem with that is the severance package or separation pay can disqualify the individual from unemployment benefits. However, if you pay them paid time off or vacation pay or sick pay or something along those lines, or holiday pay pursuant to a policy that was established prior to the separation of the employee, then that may be all right and they may be eligible for benefits. So I would just be careful about how I check my policies very carefully. Be careful to go back and look at what your set policies are and just see whether or not those benefits are going to be available. Now, for specific issues, I certainly encourage you to contact your attorney, carefully review all of the information provided by DES on their website, and understand that what may be the rule today may not be the rule tomorrow if the legislature changes. Usually they're pretty good about publicizing that, but your accountant and your attorney can make sure that you get the right information on that. Along those same lines, I added a slide here about avoiding liability in the COVID environment. We're going through some unprecedented experiences in employment situations now. I would suggest to you that there is potential for liability if you fail to follow the CDC guidelines, the OSHA guidelines for sanitation interaction with the public. You may have guidelines established by your own business association. If you do, I would definitely follow those. The issue is standard of care. People will ask me, well, what about workers' comp? If I bring my employee back and they get sick, am I going to be on the hook for workers' comp? I would think probably not, because this is probably not going to be considered a work-related injury, a work-related illness. To be compensable under workers' comp, it's got to rise out of it in the course of the employment, and it also has to be endemic to that employment. It can't be something that is readily experienced by the public at large. And so in this case, the public at large is exposed to this. So I don't know that there's going to be any basis for a workers' compensation claim. However, when you invite somebody in your business, you invite them in as a what we call a business invitee, and they're entitled to the highest standard of care. They are protected from any what we call latent defects or any latent hazards that might appear. And one of those latent hazards might be a coronavirus. If you have not taken steps to document compliance with the guidelines, post those guidelines, provide copies of the guidelines to employees, require compliance with employees, and I'm talking about taking pictures, documenting how you've complied with the spatial distance requirements, how you've complied with the gloves and the mask and all those kind of things. Take pictures of employees wearing masks, and notify your customers in advance to the extent you can as to what kind of requirements you're going to have before they come in your office. All those things are designed to protect your employees and to protect your customers. And I think they will certainly appreciate that. And I think you'll be well within your duty to them to have them. Thank you very much for allowing me to work with you this afternoon and talk with you about some of these concerns. As I said earlier, I'm no expert, but I certainly can sympathize with you. And for more information, I would recommend you contact Division of Employment Security, division des.nc.gov. You can also go to the sba.gov webpage and look, and I've listed that on the slide. cdc.gov has a section on coronavirus and a lot of good information on that. Of course, I've indicated the North Carolina Administrative Code. I also indicated a person by the name of Anne Marie Utz at Foley.com. They have a special coronavirus section on their website that I found very helpful, and it has a lot of general information about the virus. And I would certainly recommend that you contact her with issues regarding some of the legalities that are going to be arising, such as, well, what am I going to do if I can't perform a contract? What am I going to do if I'm trying to get this work out and I can't get it done, and my supplier can't get me work? And what if I can't provide it? Customer sues because I can't provide it. She has good information on some of that. Of course, contact your attorney. There's a lot of guidance in preparing the workplace, OSHA.3990-03-2020. Again, thank you very much, and I'll be happy to answer any questions you might have. And or if you would like to send questions to me at a later time, I've indicated my email address there and my contact information. Thank you very much.
Yeah, thank you, Rick. Thank you so much for all that information. We do have a few questions that were written in, so just want to bring those up. The first one says, if I go on unemployment, can I come off at any time? Then what if I need to go back on in the future? For example, if the outbreak happens again this fall?
Well, in answer to that, I would say I would say that the answer is yes, you can go back on as long as you're within the time frames. Okay. Most of these things seem to be ending about the end of July as they're set up right now, most of these programs. But I would expect that if there is a second wave, that there's also going to be a second wave of legislation that extends this longer. Okay. Mm-hmm. You're going to have to qualify each time you apply. Mm-hmm. And so I would say if you've exhausted your 12 weeks and you've exhausted the 13 weeks, then you're going to have to apply probably under one of the other federal programs. But I would certainly contact my attorney on that, or contact DES for that specific information.
Okay, great. Another question we have says, if I accept unemployment, is there any negative record on me? Will it impact my eligibility to find a job in the future or to apply for unemployment again?
I would not think there'd be any discrimination on just because you file for unemployment. It's going to depend, of course, on why. If you are deprived of your ability to work because of the coronavirus, I don't see any negative on that. I mean, that's just the way it is. Now, of course, if you leave work and you end up having to fight your employer and fight everybody, then that may be a negative to your former employer. But there again, you've got certain rights. Again, you're going to get a handout, I believe, that I've sent out that tells you what some of your rights are as an employee for unemployment benefits. So I would not let that discourage me from seeking unemployment benefits during this period.
Mm-hmm. Okay, great. Thank you. Another question we have says, as an employer, how many hours am I obligated to pay an hourly paid employee who's having to work a partial week because our business is closed and has limited hours?
Well, there again, that goes back to the 60% rule. You know, whatever their standard schedule was before they went on went part-time or went on reduced hours, you look at what they were ordinarily working. Okay, if you go back to your records and see what their average weekly hours were, and then if you had to cut them down below 60% of that, then they would be eligible for benefits. Now they're going to have to report how much benefit they receive from employment. There'll be an adjustment to the unemployment benefits they receive based on the amount that they're being paid. But I don't know of any minimum. I've got a person who's out on reduced wages right now, and I've given them a certain amount that they could work, and unfortunately they've not been able to meet that threshold yet. So they're receiving unemployment benefits, and I guess they're getting them, unemployment benefits through this because they're, with having to take care of the children and take care of family members, there just isn't a lot of time left to work, and so they're entitled to benefits because of the fact that they're having to take care of the kids when they're out of school.
Gotcha. Okay, thanks
helps.
for that. Yeah, another question we have is, what are an employer's obligations to an employee who is under government imposed quarantine? I guess could also be state, since the states are kind of.
Well, that may be a little beyond the scope of this, but what do you mean by the obligations, the employer's obligations to employees under quarantine?
I think they mean in regards to paying them, paying them while they're not working, or if they have to work from home, like what is an employer obligated in that regard?
Well, one obligation that comes to mind, it's going to depend on the size of the employer. Okay, I believe if you have more than 500 employees, then there is a federal statute and part of the CARES Act as well that requires you to pay, I believe, up to 10 weeks, not 10 weeks, up to 10 days, I believe, of vacation time. So they get like 2 weeks of vacation at whatever their average weekly wage was at the time they left. But other than that, I don't know that the employer has any duty if they can't come to work. Then their remedy is to apply for unemployment. I don't think there's any requirement that he has to keep paying somebody unless he voluntarily does so. If he's under 500 employees, then I would think that he would not be bound by any of those federal statutes that require that. So it'd be my feeling that he would not have any. It'd just be whatever he felt like he needed to do. I mean, he could also terminate the employee as far as that goes. But they can still get unemployment.
Okay. Yeah, thank you for that. Another question we have says, do employers have to pay employees their same hourly rate or salary if they're working from home?
Well, that gets into wage and hour laws, and that's kind of beyond the scope. I would contact the Department of Labor for that. You obviously, if you're under minimum wage, you've got that threshold. If they're making a certain amount, and you've essentially established that amount, if you were to cut their wages, then that, of course, is going to be grounds for them to apply for unemployment, okay, because their wages have been cut. Whether you can reduce their wage or not, that's a contractual matter. I think you ought to take it up with the Department of Labor and make sure about that. I don't know of anything off the top of my head that requires an employer to pay a set amount of salary to an employee whose circumstances change. If we may make an agreement, if you're coming to work here 8 hours a day and you're working 8 hours a day and we're doing great, and then something changes on that and you're not worth 8 hours a day anymore, then I'm not sure an employee, especially in North Carolina, that's an at-will state, is going to require the employer to maintain that same salary level. But again, I would defer to the Department of Labor on that and make sure you're not running any other kind of situation. Obviously, if you have a contract with them, that might be a problem. You don't want to breach the contract unless you go back and renegotiate the contract. So that would be my concern there. I guess I would just defer to, I'd say, talk to Department of Labor about that before you start making changes. But I can't think of anything off the top of my head that requires an employer to maintain a certain level, a wage level, in every circumstance.
Mm-hmm.
So that's what I would say. I can't think of anything off the top of my head that requires that, unless it's minimum wage. I mean, obviously, you're required to pay a certain minimum wage,
Mm-hmm.
but other than that, I think it's strictly between you and the employee. And if they don't like it, then they can apply for unemployment or they can go get another job.
Right. Okay. Yeah, thank you for walking us through that.
That's sort of
Yeah.
harsh, I guess, but that's the way it pretty much is. North Carolina is an at-will state, and so
Sure.
there's no requirements there.
Mm-hmm. So another question we have, not sure if it's really in the realm of employment law, but it is another question kind of related to working from home. It says, are businesses and other employers required to cover any additional costs that employees may incur if they work from home, such as internet access, computer, additional phone line, increased use of electricity, etc.?
I don't know of any requirement under the law that requires that. No, I don't know of anything. Again, that's not to say they won't pass something next week, that requires that. But I don't know of anything that requires an employer. I mean, that is pretty much in the discretion of the employer, to the extent that that benefits the employer's business. He may be able to take a deduction for that. The employee may be able to take a deduction for what they spend for work-related issues. But as far as the employer being required to pay for that, I don't know of any law that requires that. Okay, but there again, it seems to me, and again, I'm not a tax lawyer, and I'm not trying to I'm not trying to give you tax advice, but I think you may find, if you talk to your accountant, that there are certain expenses that you incur as a result of working at home, that you may be able to take a deduction, and that may be almost as good as getting paid for it.
Okay, great. Thank you for that. It looks like we just have about two more. One asks, is there such a thing as short versus long-term unemployment?
No, there really isn't. You're talking about long-term and short-term disability.
Mm-hmm.
Short-term and long-term disability would be a contractual issue between you and your employer. They might pay into a fund for you, or you might pay into a fund as well, or they may match money that you pay for that benefit. And if you were to get sick or not be able to perform your job, then you might be eligible for short-term or long-term disability. But there are specific rules about that. It's governed to some degree by ERISA and by other federal statutes. Has nothing to do with coronavirus unless you're sick from it, okay? If you get so bad off from coronavirus that you can't perform the regular duties of your job, and your job provides as a benefit temporary disability benefits or even long-term disability benefits, then yeah, you might be able to qualify for that. But this is not what this is. Okay, this primarily, unemployment is primarily if you can't go to work. Okay, and mainly it extends beyond whether you're able to work. You understand what I'm saying? There's a difference between being, unemployment. You've got to be able to work.
Mm-hmm.
Under the guidelines, I would say that depending on what kind of benefits you have, if you are sick with the virus and you've got to be quarantined and you've got doctor's documentation, that could possibly qualify you for disability benefits. On the other hand, that may be inconsistent with you applying for unemployment, because unemployment, the first requirement is you be able to work. That has been relaxed somewhat with the new statutes, with the way things have gone, but that's still a basic provision of unemployment. That even though you're not working, you can still get money. You still get paid for not working because you've got issues that make it unreasonable for you to go to work. Okay.
Mm-hmm.
Does that make sense?
Yeah, it makes sense to me.
It may have nothing to do with you being sick or not sick. It may have to do with your obligations that make it impossible or unreasonable for you to go to work.
Right. Okay. Yeah, thank you for walking us through that. And our final question, it says, do OSHA regulations and standards apply to the home office? Are there any other federal laws employers need to worry about if employees work from home?
Well, I'm going to refer you to that OSHA guidelines, www.osha.gov/publications/OSHA 3990.pdf, and just read that thoroughly. I think it will probably answer more than you want to know about OSHA. Now, I'll tell you this, make note as to what the threshold requirements are. OSHA only applies to certain size businesses, certain size employers. Now, I don't know whether there's been any changes made in the OSHA regulations. That's sort of beyond the scope of unemployment, but there may be some changes that have been made that have changed some of that. But as a general rule, if you don't meet that threshold, like you may have to have a certain number of employees, it may be 100 employees or 500 employees or maybe 25 employees or something, whatever the number is, you need to check that. And if you're below that number, then of course the OSHA requirements don't apply. But that does not change your obligation to provide a safe, environment for your employees and your customers. Okay, because if you don't, that's why I recommend, to the extent you can, document what you're doing, come up with your own guidelines if you need to, using these other resources to the extent you can. Some of these requirements may require a lot of expense. Some of them may not require much expense. But the point I'm trying to make is that you've got a certain standard of care, in my opinion, that you have to give to anybody that works in your office and anybody that comes in your office as a customer. And if you don't take steps to minimize that risk and try or eliminate that risk, would be better, then I think you could possibly be liable for that. So it's just as if you had a loose board in your floor and you didn't see it, nobody else saw it, they walked in and stepped in it and broke their leg. Well, that's your responsibility. You've got to protect not only from, you've got to protect them from foreseeable issues. Okay.
Mm-hmm. Yes. Well, thank you so much, Rick. And those are all the questions that we have today. Thank you to everyone who joined us. Just want to mention a few things, that you can find all of the webinar recordings and information on upcoming webinars at bbbevents.org. We've also created a resource page to help share information from our accredited businesses with consumers so they can support the local economy throughout this time. You can find information on that at bbbshoplocal.org. And finally, I want to mention our Brunch with BBB podcast. We've had multiple episodes already pushed out. You can search it wherever you find your podcasts. Again, it's Brunch with BBB. And again, just thank you, Rick, for sharing your professional insight with us today. And to all those who attended, I hope you have a great afternoon.
Certainly been my pleasure. Thank you very much, Catherine.
Thank you.